Hi, this is Jennifer, and this is my research part of our presentation today. Um, you will recall we are Group 1, and our research topic is premises liability. We're researching, as you've been told in our presentation, if a fireman enters a business to investigate a carbon monoxide alarm, um, is the owner liable for an injury that the fireman sustained as a result of a weak floorboard? So I went to Westlaw, of course, and I'm logged into Westlaw, and I am in Tennessee because that's where I want to be. And because I know that premises liability is what I want to be looking for, and I want those words to always be together, I use the quotation marks to take a first look at just exactly what comes up when you pull up premises liability. And of course, there's 568 cases that relate in Tennessee just to premises liability. So I know that's more than what I want to go through. So I go back and look at my question again, thinking about what my issues are, and and really my issue is not just premises liability, but premises liability as it relates to a fireman specifically. Um, so I want to see if I can find a case that relates specifically to a fireman. And I've used the asterisks here because I don't know if it's going to be fireman or firemen. And I checked that out, and I'm down to 4 cases, which is great. And I really liked this Buckeye Cotton Oil Company case because it said that it all depended on all the on other circumstances of whether my fireman could file a case. And I thought, oh yeah, it depends. That always is good. But then I saw the red flag and looked at it and found that this case was abandoned by this Hudson v. Gayton case. So I thought I best, and that was in 1984, and so I pulled up the Hudson v. Gayton case and read through it, and it did talk about Buckeye. Um, in here, but the very first thing is that it says in the head notes that it rejects the status distinctions that Buckeye plainly set forth of whether the fireman was an invitee or a licensee. So those common law classifications were no longer a determinative in whether the person could sue, the fireman could sue or not. So I lost my really good case that I really liked. So I had to go back and to look at some research, to look at my cases again. And I wanted to bring to your attention while I was here that Buckeye case is a 1922 case. So while I'm looking here, I see something about a fireman's rule in this first case. So I went to this first case. In My system's running a little slow this morning, and so I apologize for that. Um, and I want to see what this fireman's rule is because it sounds pretty interesting, considering I'm related to my case is a fireman. And it talks about that a citizen owes no duty of reasonable care to police officers. So I clicked on the professional rescuers or firefighters rule, and there are 6 cases listed here. And so I went to this Bridges case, and the Bridges case is a reported case in 952 Southwest 2nd at 841. It is a Tennessee Court of Appeals case in the western section in Jackson. And this case goes on to say this case actually, the widow of a firefighter said that was claiming that all all the rules weren't followed, or all the procedures weren't followed by the firemen or by the fire department or by the chief or the team leaders, and thus her husband got killed. But the case ruled that under the firefighters rule that policemen and firemen cannot make a claim against a property owner or a landowner if they're there in their line of duty or under the role of what their job is, and that the firefighters rule expects the community, because they're a part of public service, to take up any liability on that fireman's behalf. So in this Bridges versus City of Memphis case, the Court of Appeals overturned the lower court's, well, I'll get there, overturned the lower court's opinion, and denied the claim. And I'll quit going back and forth in a minute. But the case was reversed and remanded back to the lower court to finalize it based on the policeman's or the fireman's rule that they could not make a claim. So that's my part of the presentation. Sorry to be so long. Thanks for listening.